Welcome everyone. I'm Laurie Axman with PCI as our guest speaker, and Aaron Rabinowitz, a partner with BakerHostetler, is a longtime expert at the nexus, I would say, of business and intellectual property, and a close partner with PCI, working with our tech portfolio, and always provides a lot of great insights and strategic advice. So welcome, Aaron. Terry Bray is part of our program, has joined us for the program today, and he's just joined PCI as the leader of our technology marketing and licensing efforts across Penn Engineering and many other schools here at Penn. So welcome to Terry, who joins us from Georgia Tech. And with that, Aaron, I'll turn it over to you.
Okay, well, thank you very much. Thanks for the kind introduction. It's I've had the pleasure of working with Laurie and others at PCI. I see Vivian's on the call as well. So it's great to see everyone. Just happy to be here and looking forward to discussing kind of IP and patenting, especially as it relates to engineers. So yeah, thanks again for inviting me. I know the last time we did this, it was November 2020, and I remember saying at the time that I hope the next time we did it, we could all be in person, and I guess I wasn't quite right, but anyway, I think things are certainly improved since then. So it's good to see everyone again. So today, yeah, I'd like to talk about IP and patenting, and especially as it relates to engineers, and particularly to how it relates to activities at Penn and through PCI. So just as kind of a roadmap for today's discussion, I'll kind of introduce myself, and we'll talk about what I like to call the flavors of IP. Then we'll talk about patents in particular. Certainly, we'll go through some of the highlights from Penn's activities this past year, which has been a really good one for Penn. Talk a little bit about good record keeping and sort of how that relates to the patenting process, and why sort of the good records that researchers keep just kind of in the course of their everyday research, why those are really important, not just in the research, but also for the patenting side of things. And then I'll go through a couple interesting recent patenting trends and kind of wrap up and then take questions. So anyway, as Laurie said, just by introduction, I'm Aaron Rabinowitz. I'm a partner at BakerHostetler. I've had the pleasure of working with Penn for well over a decade now, and have had the privilege of working with inventors in different departments and on a great variety of technologies, for a number of years. So just kind of getting started, since it's lunchtime, I thought I'd kind of pitch this. It's sort of flavors, and I found this good image of the Philadelphia 4 major food groups, right? So we've got water ice or water ice, depending, cheesesteaks, pretzels, and hoagies. So hopefully everybody's eating lunch or soon after, because I was like pretty hungry when I put this together. So the 4 basic flavors of IP, which I think everyone's probably heard of, are copyrights, patents, trademarks, and trade secrets. And just sort of briefly, we're going to focus on patents today, but just briefly, copyrights is sort of a flavor of IP protection that relates to things that are sort of kind of expressed or sort of really memorialized in a tangible medium. So those are things where you see the copyright notice on a book, or on a CD, or compact disc, or on an audio tape. Things where you have something that's been recorded or otherwise kind of what they say is sort of fixed in a tangible medium. That's copyrights, and that really just covers kind of the embodiment of what's in that medium, kind of the words on the page in the book. Patents, which we'll focus on, I'll talk about in a second. Trademarks, I think people have heard of. They're sort of logos, words, things that are used to describe kind of the origin of a product. So you think of corporate logos like the Nike swoosh, the Apple, things like that let kind of just at a glance, or with a very quick inspection, the source of a good, so that who made it. You see a pair of shoes, they look snazzy, you see a swoosh on the side, they're Nikes, and maybe you try to find them online because you like them that much. And trade secrets, which I think people have heard of oftentimes in the context of the Coca-Cola formula, it's a type of IP that covers something that is secret. Could be the formulation for Coke. It could be the way that Starbucks or Trader Joe's decides how to locate their next store. It's not an accident where Trader Joe's places its stores. It is not an accident where Starbucks places their stores as well. But there's probably, I think there's going to be some sophistication behind the selection of those locations, and that's a trade secret. Starbucks is not going to tell Dunkin' Donuts how Starbucks locates their stores and vice versa. But that's something that's kept secret. Patents is a flavor of IP that can cover a lot of different things, and you can use those patents as we do to protect and sort of cover just about any form of technology. It could be a composition of matter, pharmaceutical, something like that, a fuel, a biofuel, things like that. It could be a medical device, things like a bone screw, implants, those sorts of things. Could be coatings, could be devices or systems, X-ray machines, MRI machines, advancements of those things, things that maybe relate to medical imaging, just as some examples. So, they can also protect processes, methods of improving something, methods of baking something, all sorts of, technologies. And what they do, patents, is they provide the owner with the right to exclude others from making or using or selling the technology that's in the patent. And that's a pretty powerful business tool, because that's something you can do to exclude your competition. If you've got a patent on something that's very foundational, you can imagine, whatever company has the patent on the touchscreen. That's a pretty powerful patent, because someone who comes along and wants to make a new smartphone, if they want a touchscreen on that smartphone, they need to come to the touchscreen patent owner. And patents can be licensed. They can be used, which is basically kind of like renting them, to others, who need access to a particular technology. You may have a patent to touchscreens, but you're not in the business of making touchscreens. So you're happy to license that patent to someone who does make touchscreens for smartphones, and you would charge a licensing fee, $5 per touchscreen or something like that. You could also sell the patent, like any other sort of piece of property or other business asset. So patents certainly very useful, especially in the context of a research institution where there's all kinds of great research going on that's of commercial and really societal value, but certainly of commercial value as well. And that can be licensed to help recoup costs related to developing the technology and to generate revenue, for the university and the owner. So as I said, kind of switching gears a bit, but still kind of staying on the topic of patents, this past year was a really successful one for Penn. I don't have to tell those of you on the call about this, but just to kind of summarize some of the things that happened in this past year, I think we'd all seen John Swartley's terrific recap message from a few weeks ago now. But first of all, in this past year, more than $815 million raised by Penn-affiliated startups. That's the most ever, which is pretty terrific in any year, certainly in a challenging year like this past one. So, a great year for startups that are Penn-affiliated, startups that may be using Penn-developed technologies, which really speaks to the value of the technology, being developed, at Penn. This past year, 142 patents were issued to Penn and its faculty inventors, and that's a record. Most patents, issued to Penn and its faculty in 1 year, and that happened in 2021. And 142 patents, that's like better than a patent every 3 days, which is pretty great. So a really great year in terms of patent kind of patent issuances. I think we're all we read the news every day. We know, the mRNA vaccines. Well, Penn's patent-protected mRNA technology was included in the first FDA-approved COVID vaccines, and it would really be impossible, I think, to sort of overstate what an impact that's had. So these are things that happened in 2021, and on top of these other things, 746 executed commercial agreements by Penn in FY 2021. That's like 2 a day. Which is pretty terrific. So I think by all accounts and from really every direction, it's been a really great year for Penn and Penn IP. again, in a really challenging year. So kind of switching gears again, where do engineers fit in, right? We know engineers, we love them. Where do they fit in, to the patenting process? And the truth is, engineers and others, but other researchers, they really fit in at every step of the patent process. And we'll talk about this a little bit more, but certainly at the beginning, engineers are developing technology, researching, testing it, refining it, and getting that technology to a kind of a mature stage. And then the engineers, the researchers, they advise Penn Center for Innovation, PCI, on their progress. Are there plans to commercialize? Are there commercial partners who are approaching? Are there plans to disclose the technology? At a conference, something like that. That's where PCI gets looped in. Engineers assist PCI and legal counsel with patent strategy, help with drafting the patent application, discussing the details of the technology, making sure that the details are described kind of just right in the patent application. And also, the researchers and engineers are extremely helpful during the patent prosecution process, where you're going back and forth with a patent examiner, explaining to them what the technology is, how that technology is different than what's come before, and why that technology is worthy of a patent. And who better to do that than the engineers themselves who develop the technology that's in that patent application. And I can speak from experience, and hopefully some of the inventors can as well, that having an inventor available to speak with a patent examiner to answer the examiner's technical questions is invaluable. And I find that anytime you can get an examiner connected with an inventor and have them sort of talk the talk and get into the details, it really is very, very productive. So engineers, are valuable at that stage as well. And certainly, the commercialization stage, engineers can help, support the commercialization of the technology, discuss it with potential partners, discuss with inventors, investors, and so on. And really, engineers fit in at every step of the process, and at all stages, and also in a very important way. And the patent process, one of the things that's crucial, and we saw this in a slide here where we talked about keeping PCI in the loop, is timing. Certainly at academic institutions, it is very much about publications and getting technology out there and getting it, sort of out to the field. But there's a danger with that, because you cannot patent, with some exceptions, something that's already been publicly disclosed. So timing is everything. So you can imagine a situation where a very well-meaning researcher, they publish an article on their new DNA sequencing technology or something like that, chemical production technology, publish their article first, then file their patent application. Seems like a good idea, seems like the natural course of things, but if you do that, then you can only obtain a patent in the United States, because in the United States, you're allowed to publish or disclose your technology before you file your patent application. That's not the case in jurisdictions like Europe and China and Japan that are outside of the United States. And if that happens, if you publish before you file your patent application, you cannot get a patent in those other jurisdictions. So the best practice, and something that we've worked on with PCI and others, is to file your patent application first, then publish the article. By doing it that way, you preserve and sort of protect your ability to obtain patent rights in that technology worldwide, not just in the US, but outside the US, in other countries that, in jurisdictions that may be commercially important. So again, keeping PCI in the loop as far as plans to publish, plans to present at a conference, those sorts of things, very important to do so that PCI can review, analyze, and make decisions about when or if to file a patent application, especially if there's an upcoming opportunity to publish or otherwise disclose the technology. We talked about that. So again, advise PCI. If we don't remember anything else from today's presentation, hopefully remember a couple things, but maybe the most important thing is to advise PCI. Let Penn know before there's going to be a public disclosure of the technology. And again, public disclosure, they can take many forms, right? There's sort of the traditional, journal publication. There used to be, it used to be that journals were published on paper, but now there's sort of an early online publication. before the kind of the official print takes place, that online publication counts. So you want to get out in front of that and beware sort of an early online publication. So as you're speaking to journals, submitting manuscripts, it's important to find out from that journal, what is their policy and practice on early online publication, because that online publication can count as a public disclosure. Thesis archiving. You think of sort of a dusty old thesis on a dusty old shelf in a dusty old library. That's a public disclosure because someone could go to that library and find it. So even though so once a thesis is archived and could be found, that's considered, that could be a public disclosure. So something to think about as you're working with grad students, others who are preparing theses and similar things, that can be considered a public disclosure. Conference presentations, in person or virtual, those can also count, of course, as public disclosures. A lot of times conferences will publish a book of abstracts or kind of condensed versions of talks or posters. All of those things can count as public disclosures. So again, keeping PCI in the loop before there's any sort of public disclosure is critical. Online only publications, things like arXiv and medRxiv, those are great ways to get technology and research out there. They are also great ways to perhaps inadvertently have a public disclosure. So again, even if you're planning to submit to kind of a, maybe an online only publication, something that's sort of non-traditional like arXiv or medRxiv or others, those count. So certainly advise PCI before there's any sort of public disclosure of the work. We talked about record keeping, and we know that researchers are terrific record keepers. Everyone keeps an immaculate notebook so they could find anything they did at any time. That record keeping is important for the research, but also very important for the patenting process. We mentioned a few minutes ago. So here's a couple things to consider when it comes to record keeping. When was the technology first developed? These dates can be important. Who's in the cast of characters, so to speak, that worked on the technology? You've got, perhaps a PI, principal investigator. They've got, their lab, maybe some postdocs, grad students, maybe an undergraduate summer researcher who worked on it. Do they have a collaboration with another institution? Do they have a collaboration with maybe another school within the university? Perhaps a collaboration between the engineering school and the biology department, things like that. Where are these other characters located? Are they at another academic institution? Are they at a corporation that's collaborating? Are they at a federal research lab? These are important things to track and to let PCI know, because these things can all impact the patenting process. Of this cast of characters, who conceived of the technology? Was it the PI? Was it the postdoc? Who followed directions? There was a summer intern who worked on the technology, but did they conceive anything, or did the summer intern just kind of carry out instructions or follow directions? Because that's very important, because you want to make sure that you know who the inventors are on a patent application. And inventors are those who conceive the technology, not just those who just sort of followed directions. What funding was used? Excuse me, was there federal funding? Was there some other form of funding used to support the technology? A very important piece of information that the PCI will need to know. Also, was there use of any sort of material that's subject to a third-party obligation? Maybe a researcher at another institution sent a sample that was then used to help test the technology or refine the technology. That's important to know, just to know, kind of who are all the cooks in the kitchen when it comes time to file a patent application. So if you think of it, I guess, in maybe sort of a visual sense, your kind of first universe of people when it comes to patent applications is who worked on the technology. But then you really want to know, again, who conceived the technology? Those are the inventors. Who had federal funding? You'd want to know that, because again, that's something that needs to be reported and tracked. So these are kind of, that's kind of the universe of information that's very important to track, which I think hopefully everyone does, but it's also important information to convey to PCI, during the course of describing and discussing a technology. And please, if anyone has questions, please jump in and feel free to interrupt. So I thought it would be helpful to just give a couple examples where good record keeping came to the rescue and really helped out during a particular patent application, just to show how valuable it is to have good records. So I had worked on a matter. I've kind of sanitized the dates and other things to protect the innocent, but imagine you file a patent application in 2004. About 4 years later, US Patent Office gets around to looking at it and they reject that patent application. They say this patent application is the same as what was described in an article by Smith. And the Smith article was from January 2004. That's before the US patent application was filed. That looks like trouble. It looks like, there was an article describing the technology that was then filed in this patent application. And because the patent application doesn't introduce anything new, it's not patentable. However, this particular technology was, so we can see that Smith sort of predates the patent application. However, this technology was supported by a grant, and the grant was filed in December 2003, which is before the date of the Smith article. And the good news is in the United States, in certain situations, if you can show that you developed your technology before something in the literature that the patent examiner has identified, you can sort of predate this piece of literature. So in our case, the inventor kept excellent notebooks and was able to show that although the patent application was not filed, was not filed until May 2004. They had been working on the technology since December 2003. So they were able to sort of predate the Smith article, and then were able to eventually obtain a patent on the technology, which they would not have been able to do if they didn't have this good record keeping to show when they first kind of conceived of the technology that was included in the patent application. So a total victory here for good record keeping. Another example of good record keeping is, and this does not involve University of Pennsylvania, but and I've sanitized everything, but you have a professor who moves from one university to another. Then they file a patent application after they come to their new employer, which I've said is based on a technology to change lead into gold. That patent application publishes, and the professor's former employer notices. And the former employer says, wait a minute, that technology that you've just filed a patent application on, that's something you developed while you worked at Alpha University. What's happening here? So there's a bit of a dispute between Alpha and Beta University about who owns this technology. Beta University would say that they're the owners because he worked at Beta when he filed this patent application. But it turns out that this faculty member's advisor at Alpha had sent themselves an email back in 2005 describing the technology and also stating that they had shared it with Professor X. So this proves that the advisor, not Professor X, was the true inventor. And because of that, Alpha University owned the patent. So again, kind of a victory for record keeping in the sense that because of good records, they were able to establish who the true inventor was of this lead to gold technology. So again, just good record keeping, it's helpful for all kinds of reasons. In particular, it can be very helpful in the patent process. So let me pause there and see if there's any questions. Anybody is welcome to unmute and ask questions if you have them. Otherwise, I'll just sort of keep going.
Hi, Aaron, I have a question.
Yeah, go ahead, please.
Hi, thanks for your presentation. Your first records to the rescue example, is that strictly a pre AIA example, or would that still be the case?
Yeah, that's from some years ago. So that is a pre-AIA example. So the question, just for the group who, for those who may not be quite as deep into patent law, has to do with sort of a change in the law in around 2013. So that example, I think good record keeping can always help. I think sometimes you I think there's more of a premium on first to disclose or sort of first to file now than what you see in that example. But there are plenty of pre-AIA applications out there, so it's it's good record keeping is still going to be important.
Thank you.
Okay. Let me sort of switch gears a bit to get off of record keeping and talk about some recent patent trends. I think with what we're seeing now with COVID and sort of other things in the world, I think it's always interesting to look at patent trends to see sort of where, just kind of where research is headed, how kind of events in the world are maybe influencing the directions that the research is taking. And it's just sort of interesting. And certainly, patent records are a great place to find this because there are a lot of patents. And the patent offices around the world, and the US and otherwise, do a really nice job of classifying patent applications into particular technology buckets, medical devices, computer systems, signal processing, those sorts of things. So you really just kind of get an interesting kind of snapshot of just what's happening in the world technology-wise at any given time. So I did a little digging beforehand and found some interesting trends that I thought I'd kind of share with with the group. So one thing that I thought was interesting, so this slide is showing kind of top patenting trends, I guess, or sort of top patenting fields by country, certain countries. This is from 2019, so it's pre-COVID. So, COVID's, and we'll talk about that in a slide or two, but just kind of beforehand, it's interesting to see just kind of how different countries have, kind of what they focus on, kind of technology-wise. And again, what this is showing is of patent applications. So looking at the US, for example, of patent applications in the US in 2019, what were the most popular kind of general fields? So in the US in 2019, computer technology first, most popular, medical technology second, digital communication third. So, you think back to 2019, things were a little simpler back then. Those were kind of the commercial priorities in the US. But, things a little bit different in some other countries. For example, looking at say, Germany, transportation was kind of the first kind of most popular field for patent applications. Second was electrical machinery or apparatuses and energy. And third, mechanical elements. So, just an interesting snapshot of maybe where the German economy was pointed in 2019. And again, you look at say Japan, things a little bit different there. Electrical machinery, apparatus, and energy, that was pretty high up. Transportation, pretty high up also. Computer technology, very high also in Japan. So, an interesting snapshot of the world in 2019. I think you could look at this and kind of come away with a lot of different, kind of different ideas, but just interesting to see, again, in 2019, at least, where countries were sort of headed kind of technology and commercial wise. But we're not in 2019 anymore. So I thought it'd be interesting to look at some patenting trends that are more recent, since really 2020 and sort of the world that we live in now. So coronavirus, obviously on everyone's mind. And it's interesting. So I had sort of put together this slide to sort of track coronavirus related patent documents. So this would include patent applications, granted patents, basically anything that's considered a patent document. And you can kind of see, if you look at the kind of the x-axis, sort of what happened by year, and you can see a couple bumps, right? So we see a bump in, sort of 2003 to 2007 or so, and that sort of coincided with kind of the SARS, kind of emergence of SARS coronavirus back then. And then remember sort of the MERS coronavirus, that was a couple of years later. You see sort of a bump there. But, neither of those quite the same as kind of what we're confronting now. And unsurprisingly, we see something like this, basically starting in 2000, well, really late 2019, but into 2020. So just interesting to see, again, it's a fairly crude, data set, but just, kind of searching for coronavirus, this is what you come up with. So kind of no surprises here, but, interesting to see sort of the ramp up, starting with SARS. And I think you can see that really put kind of the idea of coronavirus on a more, kind of more on the radar. And then interestingly, here's something that slices those data a little more thinly, looking at particular coronavirus sort of patent families. And I know this, it's a little fuzzy here, but you can see through the color coding sort of different sort of flavors, I suppose, of coronavirus in patent documents by year. And again, you can see green SARS, it's there. MERS, you can see some of that sort of bright, kind of brighter purple. And then you can certainly see, the red sort of taking off, of course, in 2020. Again, no surprise there, but this is, it's quite a spike. Another thing that I thought would be interesting to look at is kind of a more general, not just looking at coronavirus, but just kind of general technology fields as to what's happened in the last couple of years. So what I have here is looking at patent grants. So this is sort of a backward looking indicator, because when a patent is granted, it usually takes a couple of years for a patent to work its way through the patent office. So if you get a patent in 2021, that's probably based on a patent application that was filed in, say, maybe 2017, 2018. It could take a year, well, maybe 2 or 3 years. So this is sort of looking at technology fields, granted patents of technology in certain technology fields, and how the number of patents for each of those fields changed from 2020 into 2021, which is really saying what was happening in 2017 and 2018 when those patent applications were filed. So so you can kind of see in like 2018 and 2018 or so, patents matured 3 years later. And at around 2018, the year-to-year growth of patents related to computational models was huge, 35% year to year. So computers back then, pre-coronavirus, a really big growth area. Recognition of data, kind of big data processing, that sort of thing, that was growing, 3% year to year. And a couple other things were kind of declining a little bit. What's interesting is things that were sort of health related. So drug formulations, patents related to microorganisms and enzymes, medical devices, particularly things that are kind of generally categorized as devices for introducing material into the body. Those things were kind of in decline, right? You sort of look at this and, those were kind of in decline, maybe, 2 or 3%, declining for drug formulations, decline for microorganisms. Again, devices for introducing material into the body, those were declining before coronavirus. It's interesting to see. So unsurprisingly, so my next slide here is showing patent applications, which is a forward-looking indicator, percent change from 2020 to 2021. So this is looking at in particular technology fields, by what percentage did patent applications in those fields increase 2020 to 2021? In other words, how did coronavirus change things? Well, we can see it changed it in a pretty big way, because all those healthcare things that were kind of down in the red years earlier are now growth. So microorganisms, those are growing by, maybe 3-5% a year. Drug formulations were up. Devices for introducing material into the body. And a huge growth, unsurprisingly, was in peptides. That was not on the earlier list. And now it's, those are obviously related to what's going on in the world. Those are growing by maybe 6 or 8%. And peptides were not even on the previous list. So, kind of an interesting, perhaps to me, only to me, but, interesting to see just how coronavirus has kind of catalyzed, increases in patent applications in certain fields. And certainly, kind of medical and sort of healthcare fields are way up. Computational models still strong. Certainly possible that some of those models now are more healthcare related. And likewise, recognition of data, also perhaps healthcare related now as well. So just kind of an interesting snapshot into the world of just kind of where technology is headed now that we're kind of deep into the coronavirus time. So anyway, I thought this was interesting trends to see. So just to kind of summarize here, I know we covered a lot of ground, in a couple different areas. Inventors and engineers, they make the technology commercialization process happen. They're involved in generating the technology, interfacing with PCI, helping with, with patent application working with patent examiners, getting the patent approved. Those are all things that the engineers and inventors do. We talked about, if we only remember one thing, protecting patent rights by letting PCI know, advising PCI before there's any public disclosure of the technology. PCI is great. They are there to help, and it can greatly reduce everyone's blood pressure to keep PCI in the loop as early as possible. As part of that, certainly advising PCI of other developments, which may not necessarily be patent related, that may still have commercial potential. So tangible materials, software, things like algorithms, things like that may not necessarily be patentable, but may still be things that were useful or even very useful in helping to develop the technology. Because those things, again, even if they're not patentable, still have their own value, and they may have commercial potential that maybe could be realized through some work with PCI. And lastly, we talked about record keeping to the rescue. So I'll say it again, record keeping to the rescue, maintaining records of team personnel who worked on a project, the personnel's contributions, what did each person do? Who conceived this aspect of the technology? Who conceived another part of the technology? Cast of characters, that is very important. Grant support, federal support, other support, collaborators at within the institution, collaborators at other institutions, and also the key dates, dates on which you first conceive the technology, dates that you plan to publish the technology. All those things that are part of record keeping are important to track, and just incredibly valuable and useful to PCI and others in the patenting process. So I don't want to take up everybody's entire lunch hour, so I'll sort of pause here for questions. I know we covered a lot of ground, but happy to discuss anything that we saw today.
Aaron, thank you so much for the presentation, which we'll share with everyone afterwards. And I'll just kick it off. I thought your analysis of technologies that saw an increase in patenting during COVID, or just all of that was super interesting. Just one question I had for you, is it possible that the USPTO told their staff to prioritize COVID-oriented technologies that they could be reviewing at the expense of other non-related, directly or indirectly, technologies to COVID? And I'm partly asking that question because I know, especially in the first year of COVID, we at PCI did that just because we were asked to fast track anything that we thought could be a useful tool. I guess even better would be, there was a lot of innovation anyway, and just more came forward in this space. So I just wanted to hear your thoughts about that.
Yeah, that's a good question. Yeah, certainly I think there were, I think the PTO was encouraging, inventors and other stakeholders to prioritize and file, IP related to COVID. I think there, as you say, there may have been kind of technologies, maybe I don't want to say they were looking for a home, but perhaps technologies that were kind of more platform technologies that their inventors realized could be adapted specifically to COVID applications. Sort of, you can imagine something, someone might come up with a technology related to, say, a small motor, and they realize that would have application to, a miniaturized ventilator or something like that in sort of the earlier, early days of COVID. So I think you're right. I think there may have been some of both, where the PTO, whether written or unwritten, may have prioritized some things. But I think also, as you say, I think inventors and other stakeholders were either developing new COVID technologies or kind of realigning maybe technologies they had been working on in general and kind of realigning those toward, kind of COVID related, applications. But it is pretty striking to see. The other thing that I thought was interesting was, as you say, some things really jumped. Some things also stayed exactly the same. So I make no political judgments here, but you can see like reducing greenhouse gases, like pretty low both times. So,
right.
But on the other hand, I think when you have only so many resources, and your choices are coming up with something to fight greenhouse gases or something to fight the pandemic that's surging, I think you kind of, try to address the pandemic. But yeah, I think there's probably some of, all of those things happening in 2020 and 2021.
Okay, great. Thank you. Do other folks have questions? You can certainly put them in the chat or unmute. And while we're waiting to see, I'll just say, Aaron, thank you so much for very clear and consistent messaging for how to work with PCI. It's very obvious that you're a long-time partner, and also hopefully it's obvious to everyone what a great asset Aaron is for us in terms of working with patenting technologies in the tech side of our portfolio. So we didn't pay him to say any of those things, which he's just a very strong partner of ours. So thank you.
My pleasure.
Any other questions?
Aaron, I have a question regarding software. There's two camps, those who are all patenting software, those who are like, it's useless. Could you provide guidance for our faculty members as to either the best route or what are the criteria that would direct an invention around an algorithm software to filing IP versus just keeping it as a tool?
Yeah, sure. That's a good question. I guess a couple of things come to mind. I think software and algorithms, as you say, in particular, it's a little bit of a moving target, at least in the United States, in the sense that the kind of the way the patent examiners will review it's a little bit of a work in progress. There's the patent office will issue kind of new guidelines to patent examiners every so often, and everybody kind of interprets them differently. But I think in general, what I've seen is helpful is to the extent that there's software or an algorithm, as you say, that's tied to sort of it's clearly tied to like the improvement of some operation. It could be the operation of a machine or like an instrument, for medical imaging, as an example. It could be related to the improvement of the operation of something that's maybe a little less than tangible, like perhaps an improvement in the way that a database, kind of does what it does. So I think if kind of the premium on improvement is maybe a good place to, I don't know, kind of a good place to start as you're evaluating, whether to file on a piece of software or algorithm, or maybe if it's, sort of commercially useful, but maybe isn't quite the right fit for like a patent application, as an example. So I think patent examiners are comfortable, or more comfortable anyway, with things where you can kind of describe a particular improvement that's sort of achieved or realized by use of the software or the algorithm. I think, a software module that's kind of like useful, but kind of like more for convenience and not necessarily like improving the operation of, again, a machine or an instrument or even a database, that may not lean as sort of hard toward patenting that. But so I think maybe kind of looking through things through like the lens of an improvement, that's a good place to start when you're thinking about algorithms or software.
And as a follow-up question, let's assume it improves the operation of a machine and could be a tremendous improvement. How do you, I mean, the patent application is going to publish, and so providing a path to potential infringers or competitors to design around. And so how does one need to strategize in choosing what I'm telling the competition how to do it and how to go around it versus, well, maybe I'm not going to patent it and maybe not publish it either, or publish only portion of it, so that actually I keep the value of the asset?
Yeah, that's a good question. I think it's, there's always, certainly with, right, as you say, with, once you file a patent application, it, well, most of the time it will become public, and then, you can't control what the public will do with that after. I think so. There's a couple of good questions in there. I think one of them, as you say, is how do you, what about infringement? How do you, what if you've sort of taught the world how to do what you're doing? And that's, that's a, that kind of comes with filing the patent application. I think, one thing to consider is if, how easy would it be to detect, someone else infringing that patent, that patent out in the world. So if you have an algorithm where it would be apparent or pretty easily detectable, if you're looking at a competitor's, product or say you've got an algorithm on, well, for example, you've got an algorithm that improves the way that, a CAT scan machine, operates.
Mhm.
That seems like something where if you could take the competitor's CAT scan machine and kind of take it apart and figure out, what algorithm it was running, if that's easily detectable, then that might lean toward filing that patent application because you could detect infringement. If you have on the other hand, if you have something, a patent, algorithm that's very useful, but would be very difficult to kind of detect, that's something to think about because, if you can't detect infringement, then you've kind of taught the world how to perform your algorithm, but you have no way of kind of catching them, those who might do it. So I think, one question I guess you could kind of ask in the analysis, just as you said, is, how detectable would someone's infringement be? And I think, at that point, it kind of becomes a business decision, question and also, question for the technologists, the inventors, which is, how would we detect someone infringing this? And that's, I think that could sort of help, help with the analysis.
Okay.
Thank you.
Thank you. And thank you, Vivian. And I guess with that, I wanted to thank everyone for joining us.